Okay. Who is this individual that just sat down at the jail Zoom location?
Wendy Scott.
All right. This is the state of Kansas versus Wendy Scott. It is case 24 CR 346. Ms. Scott appearing from the jail Zoom location. James Watts as defense counsel. Amber Norris for the state. In an abundance of caution, I'm inclined to set this for an evidentiary hearing. Again, I'm already kind of getting these dates out there. I don't want to have any further delay in establishment of an actual evidentiary hearing date. So the court will go ahead and establish one now, because it is going to be out of ways as it is.
What do you mean by that?
You can request a sooner setting if there's some reason to do so, Mr. Watts. All right, I'm looking at Wednesday, October the 30th.
October 30, Your Honor.
Yes, I'm looking to see how many felonies we have here. I'm going to establish another 2-hour setting for this one as well. Starting at 1 o'clock on Wednesday, October 30.
Oh,
Yes, sir.
So Wendy Scott's evidentiary preliminary hearing is set on the calendar for Wednesday, October the 30th, 1 o'clock p.m. At this point, that's contemplated to be a Zoom docket. October 30th, 1 o'clock, 2-hour setting. All right. Ms. Norris, is there anything further we need to address from the state's perspective on this case?
No, Your Honor.
All right. Mr. Watts, anything further at this time?
There is, Your Honor. My client would ask you to take up the matter of bond. It's my understanding that she is currently being held on a $100,000 bond, which is obviously well beyond her ability to have any hope to meet. And I suspect was set with the intention of being it well beyond she having any hope to meet. She has 3 children. 2 of them are at home. Their 18-year-old daughter is currently watching another child. She's from Nebraska, but she's been living in Wichita for the last 3 years. She was working at Breakthrough, which is an assistant program for vets. Has been working there for a year, doing support for disabled vets. Judge, it sounds like, well, I get into that. She has a residence in Sedgwick County, in the area. She has children in the area that are dependent upon her. As I said, it appears that she has an 18-year-old daughter that's currently taking care of a younger daughter. We would ask that a bond be set that she has a chance to make. And I understand the purpose of bond. Purpose of bond is to assure her appearance. Purpose of bond is not to make sure someone is held so they can't get out. And when we set $100,000 bonds, that's typically the reason why we set them, is to make sure they can't get out. Judge, I think a bond in this case that might be appropriate would be in the $15,000 to $20,000 range rather than $100,000 range.
State's response, Ms. Norris?
Your Honor, we did request $100,000 based on her criminal history. She's likely a B on the grid, so which makes her presumptive prison. She's for sure a C based on the history that we could see. But the nature and circumstance of this crime are actually, pretty significant in that they stole from an 86-year-old woman, basically from her home, left her on the side of the road, and took her dog. She was found. Flock puts this individual in the car. The Flock systems where they take photographs of vehicles and license plates, put her in the car, the stolen car. She makes some admissions, but she has several flee and eludes. She has an aggravated battery LEO, multiple forgeries, lots of shoplifting, false informations, obstruction, tampering with evidence.
Is this from Nebraska or this is for Kansas? I've had these cases are from I could say probably 20 years back.
And Your Honor, her flee and eludes are from 2020. A lot of this stuff is from Nebraska, and it starts in 2004 and doesn't stop till 2017, which I think might have been when she moved here. And then she also has some felonies, theft issues in 2015 from the state of Iowa. She only has a Kansas ID. I don't believe she has a legitimate driver's license. The bond seemed appropriate based on the types of offenses that we're talking about here, the vulnerability of this particular victim. Her own criminal history puts her basically in a presumptive prison. She's not originally from here. She has criminal history in 3 different states. Your Honor,
Can you please? I get ECF, and I'm trying to fight to get my baby. I'm with you. I'm not gonna run. I promise. I'm not here just to be. I did not do this. I was told to cooperate with the situation, and I would get out of this. That detective lied to me. He lied to me. Completely lied to me. I didn't even know when I was questioned. I didn't even know when I was going ICU. I was laced.
Okay.
Nobody's taking none of this in consideration.
Wendy, please don't say anything else.
This court had the opportunity to review at least some of the facts of this case through its review of a prior affidavit supporting a warrant. I am familiar with the facts and circumstances of this case as outlined, I think very appropriately by Ms. Norris here on the record. I will just note that the charges in this case include aggravated robbery and kidnapping, both level 3 felonies, which would make these presumptive prison offenses in and of themselves, regardless of criminal history. And of course, obviously, the criminal history of its defendant also gives this court some reason to pause. Ms. Norris, I'm curious, was the small dog Chloe ever recovered?
not that I've heard of yet, Your Honor.
Tragic. The circumstances of this case are flagrant and indeed tragic in regards to the elderly victim in this case. The court does find that there is a public safety component to the review of any bond situation. She is a considerable run risk due to her criminal history and the fact that she's facing prison if convicted of 1 or more of these charges. She's also got flee and elude in her record, avoiding law enforcement and responsibility. And therefore, the court does believe that the bond is appropriately set, and the court will leave it where set at $100,000 cash or professional surety required. If she makes that bond, she will be restricted to the territory of Butler and Sedgwick County, Kansas only, and will be required to wear an electronic monitoring device to monitor her location. But the amount of the bond and type of bond remains the same. The request for modification is denied at this time.
Sir,
I believe that was the last matter to be taken up regarding the Scott matter. Ms. Scott, I'm not going to grant any modification of your bond. If there's nothing further at this time, the Wendy Scott matter is in recess, and we'll move on to another matter on the docket.
Mr. James, is there a way you could come and talk to me?
Yes, sir. Yes, ma'am. I can.
Wait, yep. Okay. Go! Will you hand me my screen box?
Now go freak.
Court will start with State of Kansas versus Gage Able, case number 2024 CR 341. Amber Norris appearing for the State of Kansas, Gage Able appearing from the jail Zoom location. Mr. Watts, I think this is your case.
May I?
Yes, sir. Judge, I don't have that file with me. I think it may be Joe's.
May I ask a question, Judge?
You may.
Okay. I'm not quite sure where this is going at what point in time, but for my own safety and sanity, if that's still of matter, I would have liked to have requested far before being placed in jail, that I would have been put in some sort of a witness protection somewhere away from the state of Kansas, as I've been fearful for my life for years now. And so, I mean, just to be here in front of a judge and finally have a camera and be on a court docket I can't believe that it's taken this long. I've been on the Kansas Missing and Exploited Children's list since I was in elementary school. And I have no parents. My grandparents have passed. I have no family.
Okay, you're an adult now, Mr. Able.
Correct.
Okay.
And
And you say witness protection program, that would be a program that would be essentially set up by prosecutors, not a judge.
Right.
And that usually would be based because you have witness information against others. So, I mean, I
That's
don't
not
make light of what you're saying, but I don't know if that's something for the state district court to be addressing here, Mr. Able. What I really want to address here is the status of your current case before this court. And apparently, Chris Pate was subsequently appointed after Mr. Watts was initially appointed. So there is a new attorney in your case.
Right. I don't have a record if that's where we're going with that. So I may be a grown adult now, sir, but I didn't get here by happenstance. I'm a survivor. I'm 6 years sober. I'm not trying to collect names so that I can collect a check and skip to another state. I'm from Butler County, born, bred, and raised. I'm not saying that proudly all the time. I'm just asking for a chance.
I'm unable to take your call right now. Please leave me a message and I'll get back to you as soon as possible.
When you have finished.
And Your Honor, I don't know when I don't actually have a copy of the filed order appointing, but the one that we had for Mr. Watts was file stamped July 23rd. It's, August 12th. I'm not sure whether or not he would have gotten it in time to get it on his calendar. Like I said, I don't actually have a file stamped copy of the new order that appoints Mr. Pate.
I was in contact with him. He knows of it.
Okay, so has there been a formal order appointing Mr. Pate?
Yes.
Okay. Mr. April, we're going to recall your case later in this docket. It's a long one today. So we'll call you back in a little while and we'll deal with your case again, okay?
Okay. And then before I go, may I just, if I'm able to survive and live another life, I don't want to die of a stroke in jail. I really am so unfortunate that this is a reality. And if I could wave a magic wand, I would redo it all. So I beg of everyone that can hear me, please give me a chance. That's all I have to say.
So noted, Mr. April. We'll call you later in the docket.
Thank you, Judge.
Mr. Pate, we're here on this Gage Douglas April case. And we're trying to determine the status of preliminary hearing. Is there any announcement that you're ready to make at this time?
Your Honor, as I'm sure the court's aware, I was just appointed last week. I've not received discovery nor had time to get out to the jail to see Mr. Apple. I would request either a new PHC setting or a preliminary hearing that's out a couple of months to allow me adequate time, given the serious nature of the charges.
And because of the serious nature of the charges facing this defendant, I want to get an evidentiary hearing set on the calendar without any further delay. Counsel, I'm currently looking at Monday, September 30. Quite a ways out, Mr. Pate. It's at least 6 weeks. Monday, September 30 in the morning hours. Starting at 9 o'clock.
Is this in person or Zoom?
Does the state take a position on that?
I do not, Your Honor.
And I'm available either way. I'm not available in the afternoon, but I would be available the entire morning.
This is going to be an extended hearing on a Monday morning on top of the rather large misdemeanor control docket conducted at that time. The court's going to set this as an in-person proceeding. Draper will need to be transported to courtroom B by court security. So it'll be an in-person proceeding starting 9 o'clock a.m. Monday, September the 30th. I'm going to go ahead and mark out the entire morning for this. I don't know how many witnesses will need to be called. Monday, September 30, 9 a.m. for a preliminary hearing in this case. That is obviously an evidentiary setting in person. With that established, Mr. Pate, anything else we need to address currently on him?
Not at this time. Just Mr. April, I'll be out to see you before that date at the jail.
Sure.
Right. Ms. Norris, anything further on the April case?
No, Your Honor. Thank you.
All right. The April case is currently in recess. We'll move on to another matter. This is State of Kansas versus Jesse Greenwell. It's case number 2024 CR 236. Amber Norris appearing for the state. James Watts as defense counsel. Mr. Greenwell appearing from the jail Zoom location. Sure why this case hasn't progressed further than what it has. What announcement is made regarding preliminary hearing right at this juncture, Mr. Watts?
Your Honor, I met Mr. Greenwell last Thursday at the jail. We would ask this case be set for preliminary hearing, please.
Currently, the court's looking at Wednesday, October 2.
Can I get a bond reduction?
Let's take care of our scheduling business first, Mr. Greenwell. Will that work for council's calendar? Wednesday, October 2? Currently, there was some issue raised by the defendant himself regarding bond reduction. Court will review. Originally, at first appearance, bond was set at $10,000 cash or surety. That appears to be the current order as well. What happened to the $3,500 that you were supposed to get back, Mr. Greenwell?
I was supposed to get back. I've been in jail the whole time. They've got my money.
Judge, it is also almost certainly in a evidence locker. It has not apparently been turned over to the jail as part of his property. It's in an evidence locker.
So what evidentiary value does this money have in this case, Ms. Norris?
Your Honor, without taking a lot of the court's time, I have actually not read through this case, so I really couldn't say, to be honest with you. But I mean, I suppose it might have something to do if they thought that maybe he was, working on some distribution or something of that matter. But I don't know.
What I don't know is that I don't have any documentation that the amount of $3,500 is being held. That's what the defendant related to this court, but obviously the court doesn't have possession of it.
And Your Honor, I don't know either. I can make a note to check with law enforcement regarding same.
Judge, I can tell the court the affidavit relates $3,802.69. As the current case is currently charged, I don't know if that has any relevance.
$3,802.69 was taken from the defendant?
Yes, sir.
I want to establish cash bond in this case at $3,802.69. It would appear that the prosecution, if you will, though not in direct hands of the court, this money is being held and the court will hold that money as security for his bond. Mr. Greenwell, where would you go if you were let out?
Probably to my mom's house, and I'm probably gonna rent somewhere when I get out. And
okay, where's your mom's house?
In Wichita.
Mr. Greenwell, I don't like this idea that this money got taken from you is being held. I have no indication there's really evidentiary value to it. I'm going to give you the value. We're going to hold that money as security for your release. So I'll reset your bond at $3,802.69. Acknowledge that that money is apparently being held in the hands of law enforcement and would be available to secure Mr. Greenwood's bond requirements, appearance bond requirements, should he fail to appear. We can review this in the future, Mr. Greenwell. But for now, I think that order will allow you to be released on this case now.
Your Honor, I understand the court's order, but until I get confirmation from law enforcement, whether it be people out at the jail or at whatever, the law enforcement agency that works this case, I don't know that I can. I mean, I haven't even confirmed that, whether it's the sheriff's office or the jail that even has the money.
Well, Judge, I can tell you from the affidavit, it's the sheriff's department. A find is a Michael Malott from the sheriff's department.
Well, Your Honor, the sheriff's department definitely took it when they arrested him, but whether or not it's actually in evidence at the sheriff's department, I don't have the documentation, or if it's in his property at the jail, which I don't know that I have the documentation for that.
Either way, I'm going to order a hold on the money. It's in the possession of the sheriff's department somewhere at this point.
I assume
and I'm going to use it as security for his appearance bond. And I'm not going to order that money to be released. I'm going to order a hold be put on that money pending further order of the court. But I am going to order that Mr. Greenwell is eligible for immediate release. As long as you show up, because you understand what happens if you miss the court date, Mr. Greenwell, you're going to forfeit that money on the bond.
Yes, I'll show up, Your Honor.
All right, I think you will. I think there's a lot at stake here for you. But I'm not going to let the sheriff's office take away your ability to make a bond. I just don't like it. This was all discussed back on May the 20th, and he's still sitting in jail. So,
Your Honor, I don't know if it was discussed much then, but I do know on 7/15 that it was brought up again. And I apologize. There was a note, but I did not see it until today.
I don't know about 7/15. There's no notes to that effect, but I see the lengthy discussion in the docket notes about it way back in May. So, court's made an order. I'm going to take my chances on Mr. Greenwell showing up for court when he's supposed to. And the next court date's Wednesday, October 30th, 9 o'clock for evidentiary preliminary hearing. Mr. Greenwell, I'm going to order you to be one of two places. You need to pay attention here. You need to either be in Mr. Watt's office beside him, okay, to do Zoom, or you need to be at the Judicial Center. You can always appear at the Judicial Center, and the Sheriff's Office will get you to a Zoom computer, okay? One of the two places, but they're both in El Dorado, real close to each other. I'm not going to allow you to appear by Zoom from any other location, all right?
All right. Thank you.
Okay. All right. Greenwell matter is in recess.
All right, court is calling 2024 CR 4763, State of Texas versus Francisco Ricardo Sotelo Baez. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Matthew Finch for Mr. Sotelo.
And are you Mr. Sotelo Baez?
Yes, Judge.
All right, we're here for sentencing. You entered a plea in this cause. Let me find. On July 30th of no contest and applied for deferred adjudication. According to the plea bargain agreement, the state is asking that your punishment be assessed at 6 years in the prison, and they're silent on your application. There's to be no contact with the complainant and an affirmative finding of family violence. All right, no PSI was done in this case. The court requested a criminal history. Any objection to the court reviewing the criminal history?
No objection. You're on the top page is the Bexar County, but then the latter is the TCIC and CIC.
All right, thank you. All right, court has reviewed the criminal history.
Thank you, Judge.
All right, defense state is silent. Do you have any witnesses?
I do not, Your Honor. I anticipated having some of his family members here. However, they're sick right now, so they're not in court today.
All
However,
right, do you want them to appear by Zoom?
Judge, my client has informed me that it might be easiest just to proceed today, that it would be difficult for them to be able to do that.
All right, could you raise your right hand for me, please?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Francisco Ricardo Sotelo Baez.
All right, sir. Your attorney has told me that they don't have witnesses present. Off the record for a moment. Excuse me. All right, we're back on the record. Mr. Baez, if you want, the court will have your family members or whoever you wish to testify to appear by Zoom. We can make that arrangement if you would like to. Otherwise, we can proceed.
We'll proceed. I already talked to my mom, but they're sick right now. My sister's sick right now. They said it was a virus, and my mom doesn't really know how to use the phone like that.
All right. So defense, if you've had a chance to talk to the witnesses, if you want to make a proffer to the court of what they would say, the court will take that testimony.
I can, Your Honor. When in my closing remarks, I can do all that.
All right. Any questions for your client?
Mr. Sotelo, we're here today. Would you like the court to grant you the deferred adjudication that you'd applied for?
Yes.
And you understand she has the discretion to do that?
Yes, sir.
And you understand that you would be obligated to follow any conditions or rules that the court imposes on you?
Yes, sir. I do understand.
And you understand you have several other things.
You need to speak up. So the
Yes, I understand. Sorry, Judge.
And is it your intention to do what you can to be compliant if the judge grants you that probation?
Yes.
Okay. You've accepted responsibility by entering a plea before this court. Do you? Can you kind of the right way? Explain to the court what you're asking for today.
I would really want you to give me a second chance to redeem myself. I just had a newborn that was born on June 23rd. I want to be out there for my family. I'm 23 years old with 5 kids. I have 5 kids right now with the same girl. I really want to be part of their lives. I don't want to go away to prison and show my kids that I could be a role model for them. And also, I help my mom and my dad out to pay rent as well. I'm always working for them too. Take care of my little brother también. And I would really want a second chance. I promise you I won't mess this up. It's my first felony I have, and I'm not gonna mess this up. It's my first and last felony. I'm again. I've been trying to change my life around, going to church and in jail. I really want to see if you could please help me out with this. My bad. My English is a little. I know more Spanish, but.
Oh, no. Do you need, here's the thing. Do you need an interpreter? Because I want to make sure.
I understand. It's just that English, I speak it too, but right now, because I'm in front of you, I get a little bit nervous.
Well, let me just tell you, there's no need to be nervous in front of me. There's no need to be nervous about your English. I always say people who speak more than one language are very intelligent because learning a second language is very hard. And people tell me that the English language is one of the hardest because you have two TWO, TO, TOOO, and it's all pronounced two. So if you want an interpreter to be brought down, it will take us probably 5 minutes to get an interpreter here. If you would feel more comfortable speaking in Spanish, we can have an interpreter to come down. It's not a problem.
That's fine, Your Honor.
Okay.
I'm good speaking to you. My bad is just that I really get nervous.
No problem. Any other questions?
You got all pass at this time.
All right. Any questions?
No questions from the state, Your Honor.
All right. I have some questions.
Yes, Your Honor.
All right. So the child you hit, how old was that child?
She's 2 years old.
2. All right. And you say she, but in the police report, it says son.
Yeah, well, I have 3 daughters and 2 sons now.
All right. So the person that you hit in this case, I'm sorry?
It's a he.
I'm sorry, what?
It's a he.
All right. And how old is he?
He's 2 years old.
All right. So why is it in the police report? This is what they said. You texted his mother and you said, you're not going to like what I just did. I hit your son. Why are you calling the child your son?
Because, well, it's our son. It's my biological son.
But why you just?
Yeah, it's baby's. He's a mama's boy. So.
Oh, he's a mother's boy.
He's mama's boy. So.
Okay.
He's always. I told her. She told me the same with my daughters because my daughters are daddy's girls, you know.
Okay.
And.
So why are you hitting a 2-year-old? What was the reason?
I had a lot going on today. I had got into a fight with my family members. My wife was in the hospital.
So you get in a fight with your family members. Your wife is in the hospital. So how does that translate you to hitting a 2-year-old?
I did wrong. I know I did wrong.
No, I mean, what I'm trying to figure out what was the cause. I wasn't there.
Well, what happened was that with my son, I'm a little bit tough with him because he was my only boy. He was surrounded by girls, and
you're a little bit tough with the 2-year-old. Okay.
Yeah, and I would want to play with him. I would want to play with him with the cars. I'll buy him cars. I'll buy him robots, boy toys. But he didn't want to. He wouldn't want to play with toys.
Okay, he doesn't want to play with toys. What does he want to play with?
He wants to play with Barbies.
All right, so he wants to play with Barbie dolls. So that was your issue with him.
And then my wife and my mother will tell me my son was going to be gay. And for me, feeling that way, my first son to be gay.
So your thing is, let me hit my 2-year-old because people are telling me he's going to be gay.
That was my first time laying my hand on him.
No. I'm just trying to get into your thought processes. So people are telling you that your son's going to be gay because he doesn't want to play with robots. So let me ask you this. Would G.I. Joe, those toys, because those are dolls, would that be an issue?
I don't know what G.I. Joe is.
Oh, okay. I'm showing my age. Nobody, Snake Eyes? What? Well, you do know they have Ken. For example, Ken. That's a doll. That's, I guess that's Barbie's sometimes boyfriend, or maybe it's sort of like undecided. I don't know if they're together or not. But Ken is a Barbie. So how would you feel about your son playing with the Ken doll? You just don't want him playing with dolls.
I didn't want him playing with dolls.
Oh.
My daughters have like little kitchens and like dressing dolls and all that.
And so he would play with the kitchen set?
He would play with the kitchen set and all that.
All right, so
And I'll buy him like trampolines and like a little soccer field. And he didn't.
Yeah, I want to play soccer.
With that.
I don't want to play soccer either. So he don't want to play soccer and he plays with the kitchen set. So I guess males who are chefs, that's like a girl job, right?
Well,
I mean, wouldn't that be considered a gay job then if you have male chefs in the kitchen? I'm like, all these men who are walking around out here being chefs, you're telling me that they're gay.
yeah.
So then you hit the 2-year-old and you cause his nose to bleed. And then it says the victim had injuries, bruising and swelling on the face. And they say you sent a text message and said that you hit the victim 4 times in the face by slapping him. In what world is it okay to slap a 2-year-old in the face? What did you think you were teaching him?
Nothing.
Like to be afraid of you?
No, not really.
I mean, did you think the 2-year-old was not going to be afraid of him? Because 2-year-old, I don't think he's 6 feet tall. You're standing over him, slapping him. Did he cry when you slapped him?
Yes, Your Honor, he did.
All right, when his nose is bleeding, you continued to slap him. Did he continue to cry?
Well, I don't really remember his nose bleeding, Your Honor.
Did you get him some tissue? Did you clean up his face? Did you apologize?
Cleaned up his face. I spoke to my wife. I apologized to her.
No. Did you apologize to the 2-year-old?
Yes, I heard that.
And did you apologize to your daughters if they were at home and witnessed that?
And my daughters were in the other room.
They were in the other room?
Yes.
So you think they don't hear him crying? Do you have like a west wing and an east wing to your house, like Dallas?
No.
Like South Fork?
I apologize to all my kids, Your Honor. I know, I have an older daughter that she's 5.
All right, it says here that you stated that the mother says that you're always unnecessarily hitting or disciplining the victim due to him being more feminine and wanting to toughen him up. So you think you beat up a 2-year-old by toughening him up, because that's what this is. You beat up a 2-year-old. You beat up a 2-year-old. And then I'm looking at your criminal history. You have other assaults. Who is the other family violence assault against? Was that against the mother of your children?
Yes.
All right. So why do you continue to hit people that you claim that you love?
Because I was in the wrong, man.
No, but why are you doing it? I don't understand.
I wasn't right. I don't know if I can say it.
All right. What I can tell y'all on this case, I don't have the trial court certification of defendant's rights to appeal. It's missing.
I'll re-execute it, Judge.
All right. Could you grab that for him, please? Yes, there's something you wanted to say?
Yeah, it's because I was in drugs and I had tried a new drug I had never tried before. That's what made me like it.
Well, here's the thing. According to what I'm reading in the police report, this isn't the first time that you've hit the 2-year-old, according to the police report, right? Is this the first time you hit him?
Yes, sir.
Not according to the police report. And it says that you're always disciplining him unnecessarily because you're trying to toughen him up because you think that he's gay.
I'm not thinking he's gay, but my parents, my mom.
Oh, I'm so sorry. You know what? Here it is. I found it. Thank you. And then what kind of grandparents does he have in his life? If what you're saying is true, where they're like toughen him up. We don't want a gay grandson. What kind of nonsense is that?
Oh, he's grandma's boy too.
So in
But
your,
it was just to get me mad.
well, here's the thing. In your son's 2-year-old life, he's already had trauma and drama caused by you. So now he thinks men are gonna beat him up. Any other questions?
No, Your Honor, just argument.
All right, I'll hear argument.
Your Honor, obviously the facts are not the best. My client did make some pretty grave errors in his dealing with his 2-year-old son. He's learned that as in our conversations, as you said, in jail since this happened. Judge, his family has been involved. I think they would be a great support system. I think they understand the significance of what has happened. I'll point out that my client is 23 years old and has 5 kids, Judge. Probably hadn't had any formal training. If there's drug issues, if there's domestic violence issues, there's a lot of different programs within the probation department, like the BIF program and drug counseling and TAP evaluations that can focus on that to ensure that he has a chance to be successful on probation, Judge. In addition, Judge, my client is not a citizen. There's been a PDA consultation with the Managed Assigned Counsel program. And knowing that my client is still before this court and asking for some leniency, but Judge, he also has a pending ICE hold. It's a fact. So
Sorry, a pending what?
ICE hold, Judge. There are proceedings going on. He will visit an immigration judge after this is done. So if he is granted probation, he still has that to deal with, Judge. But we're just asking that he be given an opportunity to learn from his very poor decisions that he made. He's been very straightforward with the police, with all the reports, and with this court today. Whether it's right or wrong, he clearly needs to learn to how to raise children better. And I think the programs that the probation could offer in any reasonable condition that the judge would want to impose would be able to assist him in learning so that this cycle doesn't happen again. Judge, but we're asking for a stretch. We're asking for a little bit of mercy. My client is hoping to get probation. We'd ask that you consider that. He's got a lot of work left with him. His decisions that day impacted his family, not only because of this case, but everything else, their entire lives and going on, and even my client's ability to possibly remain in the country. Judge, with that, we'd ask that you take that into consideration and give him that chance. And he understands that if he gets deferred and messes it up, he has the full range of punishment. So he understands that there could be an even more significant punishment if he doesn't change his ways and engage and cooperate with probation and whatever orders this court makes.
Okay. So you said you have 5 children. So I see here it's Rodrigo, Delilah, Veronica, and Laura. Who's the other child?
But he was just born on June 20th.
What's the name?
Tadeo.
How do you spell that?
T-A-D-E.
T-A?
No, T-A-D-E-O. Ricardo Sotelo. He was just born on June 23rd.
Okay. All right. Is there anything else?
No, Your Honor.
All right. The court is going to find you guilty. The court is going to sentence you to 6 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Rodrigo Sotelo, Delilah Sotelo, Carla Cruz, Veronica Sotelo, Lauro Sotelo, and Tadeo Sotelo. There's to be no illegal reentry to the U.S. and there's to be no contact with minors. I'll order the therapeutic community. Maybe they can help him. Yes. Yes, you have a question? You have a question or no?
I just wanted to see a second chance.
I'm sorry, what?
I just wanted a second chance to redeem myself, please, Your Honor.
All right, we're off the record. This is what I want you to understand. I internalized everything that your attorney presented, and your attorney presented some great arguments. in your past, you have assaultive behavior against the mother of your children. Probation for that, they would have given you the BIPP course. It's legally required. You have learned nothing. You beat up a 2-year-old because you think your 2-year-old is gay and you want to toughen up a 2-year-old. He's 2. It's like, imagine yourself in a boxing ring and your opponent is a 2-year-old. The 2-year-old doesn't stand a chance. The 2-year-old is going to, lose every time. You hit him in the face, give him a bloody nose. And according to the police report, after you hit him in the face, I'm sure he's crying, and you continue to hit him 4 more times. Then you text his mother, you're not going to like what I've done. I hit the 2-year-old. And then the mother in the police report and everybody in the police report tells me, you discipline him unnecessarily because you think he's going to be gay because he likes to cook. Go tell Wolfgang Puck. You know what? What if Wolfgang Puck's family would have thought, Wolfgang is going to be gay. We're not going to let him cook. Right? Have you ever cooked your own meal? Are you gay? Then why are you beating up on a 2-year-old because he likes to cook? To me, that would be a great thing because everybody is out here, you, having children that you can't take care of. You're 23 years old and you have 5 children. It would probably be nice if you had a teenager or somebody in the house who loves to cook and you encourage that. Then guess what? That's no cooking on your wife's plate. It's off the table. You understand? You are not to have any contact with minors when you're released. You're not allowed to come back to the United States unless you're here legally. And I can't stop you from having children, but if you can't financially take care of your children, if mentally you're not ready, which it appears to me you're not ready, if you're going to be violent, then you shouldn't really be around children. You shouldn't be having more children. Do you understand? All right, good luck to you. For the offense of assault, bodily injury, family on September 21st, 2018 for a period of 1 year. Is that you?
Sure, yes.
All right, state.
We're moving forward with condition number 5, Judge. Like me to read it?
Yes, please.
In Bexar County, Texas, the defendant, Delia Ochoa, did then and there fail to report to the supervision officer in person and or by mail for the months of December 2018, January and February 2019, in violation of condition number 5.
How do you plead to that? True or not true?
Sure. The state will be waiving and abandoning the remaining conditions.
Any objections?
No objections, Judge.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is, Judge. We ask that you grant the motion, revoke community supervision, enter adjudication of guilt, and enter an affirmative finding of family violence for 180 days in judgment.
All right, anything you wish to say on behalf of your client?
That's our agreement, Judge. We just asking the court to follow that agreement.
All right, and you understand the court does not have to follow that agreement?
Yes, ma'am.
Can you raise your right hand for me, please? You can lower your hand, state your name for the record.
Delia Ochoa.
All right, what have you done on probation?
On probation?
Yeah, what have you completed? Have you done anything?
It was 5 years ago, 6 years ago, and I thought I was already done with everything. That's what I was told, and I went back to jail for another week, and I was supposed to have been dismissed out of my record.
All right, this was before my time. So
that's why I was like, I didn't know what was the reason the warrant was for the same charge.
So your answer to my question is you've done nothing?
No.
Well, what have you done since you've been on probation? Since 2018, what have you done?
Just worked.
All right, so you have done nothing on probation.
I don't understand the question.
All right, for probation, you have to report. Have you ever reported?
No, ma'am.
All right, so you've done nothing.
No.
Okay. Probation, has she done anything on probation? All right. Here we are. All right, this is what the court is going to do. Court is going to find you guilty grant the motion, revoke you. There's an affirmative finding of family violence. There should be no contact with Maria Ochoa and Evelyn Vasquez. Court is going to sentence you to 1 year in the Bexar County Jail. Give you credit for any time served. There's a $4,000 fine. Time and money will not run concurrent. All right, we can go off the record. Here's the thing on probation. You just don't get to live your life the way you want to live it. You're supposed to report. You did not. They never saw you. So good luck to you. Thank you. Samantha Mendoza. Hello. So counsel, have you received all discovery?
Judge, I have. I'm here because Ms. Mendoza requested that I withdraw. And in the past, I had always brought those to the court's attention. I generally see the court reject it. But recently, the new thing that is done over at the jail is they request you withdraw. Then they file a bar complaint against you. And then 20 hours later, as a lawyer, they reject the bar complaint. They end up getting another lawyer who doesn't do any better. And you've spent 20 hours of your time. I've done this 2 to 3 times in the last.
Oh, no, here's the thing. Ms. Mendoza? Hi, how old are you?
I'm 31.
All right. So if you want an attorney, then you need to, if you want a different attorney, you need to hire an attorney. Do you understand?
Okay, I understand, but he's basically telling me like these classes don't.
No. Here's the thing. Let me explain something to you. And this is me talking to you as somebody who's been a defense attorney, somebody who's been a prosecutor. Sometimes I would have clients who would think that what they're telling me would help their case. And it wouldn't. It had nothing to do with the price of peaches. But it's always nice for clients to take classes while they're in custody, to try to get their life in order, so that maybe if an agreement is worked out, that's something that can be presented to the judge. In this court, this is the process. I make sure that the defense has all of the discovery. What does that mean, discovery? It means that he's been given everything that the state has about your case so that he can properly prepare for your case. Then I require that the state make an offer to the defense, and then the defense is ethically obligated to present that offer to you, and then you can either reject it or accept it. If you accept it, then there will be a plea agreement. I will accept the plea. If you reject it and you all are not able to come to an agreement, then it will be set for trial. Here's the problem that I see a lot with people who are charged with cases. They think that attorneys, all we do is talk. They don't think there's anything behind that. But guess what? Every attorney that you see in here, one at least has an undergraduate degree. Then they had to go to law school. And when you see attorneys talking, there's knowledge about the legal world and experience based upon their life and based upon what they have done. So just like you wouldn't go to a doctor if you needed a heart surgery, I guarantee you wouldn't be telling that doctor, and I know you're not listening to me, but I don't believe you would be telling that doctor how to do a heart surgery. I don't think you'd be handing to that doctor and saying, hey, let me show you this paperwork where I went to go to listen to somebody speak about something. And you wouldn't expect that heart surgeon to say, you know what, you're right. This is how I'm going to do that surgery. But for some people, some reason, people feel the legal profession, just anybody can do it. And you know what? If anybody could be in the legal profession, then we wouldn't have law schools, and then anybody could have their bar card, and anybody could do what attorneys do. So what I'm telling you is, this is not Burger King. If you want your own attorney, that's the way to get Burger King service. The way you want it, you go out and hire an attorney. And I guarantee you, when you hire that attorney, he or she will tell you, there are a few things that as a defendant, you have a choice over. You have a choice. Am I going to testify at trial or not? Am I going to accept a plea bargain or not? Those are some of your choices. But trial strategy, that's not within your purview. That's solely within the defense attorney's purview. So This attorney is willing to speak to you. This is the attorney who's been appointed to represent you. But what I can tell you is this train is going to keep moving. You understand? So all discovery has been received. State, were you able to tender an offer? Were you able to talk to your attorney about the offer that was tendered?
Yes, we talked about it.
Do you need more time to talk to him about the offer?
Yeah.
All right, so if y'all will sit in the box and he will talk to you, then you can reapproach counsel.
Sure, thank you.
All right, court is calling 2023 CR 5280, State of Texas versus Kevon Alfred James Jones. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
David A. Garcia, attorney for Kevin Jones.
And are you Mr. Jones?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Kevin Alfred James Jones who was placed on community supervision in 2023 CR 5280 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on January 22nd, 2024 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 1 on or about the 22nd day, May 2024, in Bear County, Texas, to defendant Kevin Alfred James Jones committed the offense of evading arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
Your Honor, we'll waive the remaining violated conditions. No
Any-
objection.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, sentence you to 9 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There's Your Honor.
Yes.
And it's a deny the motion to revoke, continue and lower probation. The state is taking into consideration clause number 766366 and also to have the individual attend state ISF. That is the agreement, Your Honor.
All right. So why is he continuing to violate? Why is he violating probation?
Well, Judge, if you look at the 3 conditions, 2 of which have now been waived, the evading, I conferred with the state. It was something I've actually filed a motion for continuance because when you look at the police report, it was an execution of a search warrant at a location not my client's. And he was outside of the house. When the police arrived, everyone ran. My client states that he heard bangs. He was fearing for his life. So he ran and hid. And they found him hiding behind a shed in the area. The report from the probation department shows he's been clean. So that was a stupid mistake, Judge. The state and I looked at it. The motion was to get the video, but we worked out this deal. He's been sitting in jail for 2 months. His mother's present, who supports him and loves him. Other than that, the other violation was something about proof of change of address. And I think when he was arrested, he gave his father's address or something, which is different. And then I think the last one was not completing community service or something like that. So he's been working on doing well. We're hoping that the three months in ISF will make sure that he understands he cannot afford any mistakes. And we're hoping that you grant him this opportunity to prove himself and keep him on probation.
All right, and state with regards to this evading, I haven't seen the police report.
Would you like the police? Pretty much the rendition is that it was a drug house that he was standing outside of and with another gentleman. When the officers arrived at DPS, they did run off and did not stop when asked to stop, and that's the evaded.
All right, thank you. You may continue to confer.
Thank you.
Why is it takes people to get arrested to decide they're going to change their life and they want to do things differently? He should not have even been outside a known drug house. And I don't want to hear, I didn't know it was a known drug house, because if you live in a neighborhood, no matter where you stay, you know what house is the house that you shouldn't be at.
I think the gentleman he was speaking to was his uncle, which doesn't excuse where he was, Judge, but that's the situation we have.
And doesn't excuse giving fake addresses, doesn't excuse any of this. How old are you?
25.
You want to raise your right hand for me?
Yes, sir.
All right, you can lower your hand. State your name for the record.
Keegan Jones.
Do you know what your conditions of probation are?
Yes, sir.
Do you know part of your conditions of probation, you can't hang around people who've been in prison, who are out of prison, who are on probation? Do you realize that?
Yes, sir.
So is your uncle out of prison, been on probation, any of those things?
10 years ago. Yes, ma'am.
You can't hang around him.
Yes, ma'am.
You can't hang around any family member who's been in and out, well, who's been to prison, out of prison, on probation. It's not allowed while you're on probation. Do you want to go to prison? Then why are you behaving like you want to go to prison? Why? Why? You're 25. When are you going to grow up? And stop asking your mom to come down and cry and do this for you. Your mom should be enjoying the best days of her life, not dealing with someone who's 25 years old. You're a grown man and you're behaving like a child. When's the last time you had employment?
Before this happened.
Doing what?
Working at a moving company.
And how far did you go in school?
I graduated.
And what are you planning on doing with the rest of your life? Other than hanging out with people you shouldn't be hanging around?
Need to stay out of trouble.
Well, everybody, I'm staying out of trouble. Are you staying out of trouble?
I try, Judge. I don't.
Everybody's staying out of trouble, unless it's good trouble.
Yes,
You're staying in bad trouble, and then you come to the court and you want to beg me to give you another chance. And you bring your mom down here when she has to pay for parking. I don't know if she drove or if she took the bus, but she could have been doing something else with her day.
Yes,
Instead, she's dealing with a grown man who don't want to behave well. Probation, is this what you all are asking for?
Yes.
All right, I'll deny the motion. Alternate amend conditions to include the MRT, ISF, and upon release, I want him on GPS. And it's going to be partial, and it's for employment only. So what that means is you're going to be on GPS. The only thing you're allowed to do on GPS is go to work and go back home. Who are you going to be living with?
Mother.
Does your mom want you living with her?
Yes.
Did you ask her? That's either yes or no.
Yes.
If I call her up here, is she going to say you asked her, can I live with you?
Yes.
All right, so I see you looking up to see. Is he allowed to stay with you?
He does. But he's gonna abide by what I say.
All right, if you can come forward, please. Move over there. All right, can you raise your right hand for me, please?
Yes.
All right, you can lower your hand. State your name for the record.
Anya Bledsoe?
All right. Is this your son?
Yes, ma'am.
All right, he's saying that he has your permission to live at your home. Is he allowed to live at your home?
Yes, he is.
All right. So he's going to be on GPS. He will only be allowed to go to work, then he has to come home.
Yes, ma'am.
If he violates those conditions, a motion to revoke is going to be filed.
Yes, ma'am.
Is there anything else you think your son needs to be successful?
If I tell you,
No, tell me.
you need to listen.
Okay.
I say, your people are the wrong. Your choices of the people are the wrong thing in your mind. You can't get over. He was raised the correct way. So what he has done it doesn't make any sense. Following somebody is no good. Be a leader.
Mm-hmm.
That's what I try to teach him. He's a good kid. He really and truly is. It's just like I say, following the wrong, even family. Because I have to cut mine out too.
Mm-hmm.
So he will work. He helps me out with everything. He's a good kid, very mannerable and everything. And not to bring up when he was with you first time, I told him,
You went up there and you let that lady tell you when you shouldn't have even acted like she wasn't talking to you. And I told him, you are to apologize to her. You know, that's the proper thing. That is the proper thing because he wasn't raised like that. You know, I love him to death, but I will. And he has left home before. I told him, you think you're gonna run around here and do what you wanna do, get your things and go. I'm not gonna deal with that.
Okay.
So, I spoke with him this time. Yes, he did, Mom, I'm gonna do the right thing. Okay, because I will call the police. I will turn him in. I don't have a problem with that because I don't need the headache.
All right, so let me just tell you, I'm gonna make sure you give your address to probation because when he's released from custody, that's where he's gonna be staying. And she will give you the phone number of who his probation officer is gonna be.
Yes, ma'am. And I do believe as far as that address thing, on his ID is 522.
Oh, no. Here's the thing. I'm gonna continue him. We're starting from ground zero right now.
Okay.
So he's gonna know where he needs to stay. And that's where we'll be, okay? All right, thank you.
Thank you. And Judge, regarding the GPS, can
All
we
right.
waive the fees?
Oh, just 1 second. Come back up, Mr. Jones. All right. Oh, don't be bowing your head like you have some kind of shame. Your mother is saving your life. You understand?
Yes.
All right, the court is going to deny the motion, alternate amend conditions to include MRT, ISF upon release, and he's to remain in custody until transferred to ISF cognitive. There's going to be GPS partial for employment only, waive GPS fees, and it's going to be proof of employment within 30 days of release. And you are to reside with your mother until further notice.
That's state ISF, right, Judge?
Yes.
Thank you.
Probation, is there anything else he needs? All right, we can go off the record. Here's the thing. You may think you're an adult, but guess what? You're going to be living in your mom's home. So if she has her rules, if she wants the television off at 10, television goes off at 10. If you want to make your own rules, you need to get your own place. And I'm telling you right now, you are not allowed to leave your mother's house or go live somewhere else without the court's permission. Do you understand?
Yes.
Is there anything you do not understand?
No.
Anything else you need from the court to be successful? All right, thank you.
Thank you, Judge.
You're welcome.
Good luck.
All right, court is calling 2024 CR 3748. And this will be our last case, State of Texas versus DeAndre D. Can I have parties announced for the record for the state? Defense? And are you Ms. DeBuriel?
Yes, ma'am.
Counsel, have you received all of the discovery?
To the best of my knowledge, yes.
Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. DeBuriel, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Proceeding on count one and waiving count two.
Any objection?
No.
Did you understand in count one, you're charged with assault, bodily injury on a security officer? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Did you understand?
Yes.
According to the plea, state is proceeding on count one. There's a $400 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, we just asked for consideration as to the fine.
State, is that the plea?
It is, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There be a top evaluation, 120 hours of community service restitution, no contact with Benjamin Mendoza and Colin, Colin Johnson, anger management classes. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense as charged in count one, how do you plead? Guilty, Not guilty or no contest?
No contest.
All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court would defer finding the guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, please.
All right, so what started this argument at the Shoe Palace?
So it had nothing to really do with me. It was just me and a group of my friends. It was someone's birthday. We were just in the mall cashing out like $3,000 worth of stuff. So it was girls behind us. One of them got behind my friend, and I told her, I said, "Hey, it looks like this girl is gonna hit you." Next thing I know, this girl did hit my friend. Mind you, I moved out the way. I didn't fight. I didn't do any of
Can I
that.
ask you this, please, so that just.
Oh, I'm so sorry. So we're just buying stuff up at the mall. One of the girls was behind my friend. I told my friend, "Hey, this girl is looking like she's gonna do something to you." The girl actually did hit my friend. So the people that I was with, everybody fought except for me. I'm on the sideline. You can see it on cameras. I'm on the sideline doing nothing. So I walk out of the store and we're all walking towards the exit. 7 or 8 security guards run up behind me, and the guy didn't even give me a chance to say anything, do anything. He was aggressive towards me, and I got scared. And I told him, "Hey, get out of my face, da 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 da, whoop de whoop whoop."
Okay, let me ask you something. Do you think the court reporter can take da 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 whoop whoop whoop
No,
down?
I'm sorry. No, ma'am.
So, Maria,
Yes.
that's da 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 whoop whoop whoop, and I may have missed one of the da 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 dots.
I'm sorry. So they just started. So the security man.
All right, so let me just tell you.
Yes, ma'am.
Security guard is saying you caught him in the eye with your fingernail. Were you wearing those nails?
They were longer, and I'm sorry.
They were longer?
Yes, ma'am.
So it caught him in his eye.
Yes, ma'am.
That's why we're here.
And I do apologize about that, but at the same token, if 7 men was coming at you, you would be scared too. If 7 men threw you into an iron gate, you would feel the same way I do.
I would have picked up the phone and called the police
Oh,
if
they
I'm
was
at the
already-
Shoe Palace.
They were already there. That's the
Here's
thing.
my question.
Yes, ma'am.
Why was a girl behind your friend looking like she was going to hit her? What was going on?
They was hating on us.
All right, why?
Because we was in the mall just catching up, just spending a lot of piece of change. That's a nice mall, spending some money.
Shoe Palace?
No, okay, well, I like shoes. I don't know about everybody else, but we spent a lot of money in the mall that day.
And which mall was this?
The one that's got the big boots on the outside of it that I'm not allowed to go back
Nordstrom?
to.
Okay. All right. You know what somebody said in a program that I watch? He said, wealthy people don't spend their money on fancy items because they're wealthy. They don't need to spend a lot of money so people can see that they're wealthy. He said poor people, some, will never obtain wealth because they keep buying stuff to show that they're wealthy. Like, I never understood when people would buy, like, for example, the Hermes bag. That bag is like $20,000, maybe more, 120,000. Some of them. It's like people buy that bag, 120,000, poor people financially, and they don't have $20,000 to put in the bag. They like maybe have $100. But here's the thing: you got in a fight at the Shoe Palace, and the security guard got hit by your long nail.
I didn't.
If you would have, here's the thing: if you would have had your natural nails on, maybe he wouldn't have been injured.
Mm-hmm.
But this is where we are. So the people you were with who are listed in here: Tahaya Lovejoy, Linda Marie Lovejoy.
Who? I don't know.
You don't know any of them? Okay. All right. This is what I'm going to do. Are you employed?
Yes, ma'am.
What do you do?
I'm an AGM for a management company for hotels. An AGM and assistant general manager.
All right, the court is going to sentence you to 3 years deferred adjudication. There's a $400 fine that will be probated. Do you have any children?
No.
All right. There's to be no contact with the following persons: Benjamin Mendoza, Colin Johnson. I think this is Tahiya, TA'Khiya Lovejoy, Linda Marie Lovejoy, Tanisha Lauren Jones, Laurin. I know you say you love shoes. Not at the Shoe Palace anymore.
Okay.
So no contact with the Shoe Palace. And I tell you what, I'll do no contact at the Shoe Palace at North Star Mall. Far be it from me to take away your ability to go to all the Shoe Palaces.
Okay.
So Shoe Palace at North Star. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Anger management course. Regular random UAs. Field visits. 1 time per month for 2 months. All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let probation know. If you feel as though they're not addressing it, you can come back to this court and we can compare sheets. All right. Probation will speak with you. You're excused.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an absolute. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in first. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so let us feel. I'm sitting up here, I'm the one that needs a drink.